This lecture focuses on what we describe as party liability in Canadian criminal law. A good place to start is with the observation that under Canadian law, the party who assists, who abets, who encourages the principal actor to engage in a criminal act is regarded as morally equivalent or equally blameworthy to that actor. Indeed, we can see this idea reflected in section 21 sub 1 of the code, which sets out who constitutes a party to an offense. And you'll see something rather curious. You'll see that section 21 sub 1 sub A specifies that everyone is a party to an offense who actually commits the offense. In other words, you're a party to an offense if you're the principal actor to the offense. And doesn't that seem strange? Mustn't it be the case that you are either a principal or a party? Well, in a sense, that's true. But what this section articulates is it doesn't matter for the purposes of criminal liability which you are. And therefore, the Crown doesn't have to peril its case for liability on characterizing you as one or the other. Put differently, if we have some doubt as to whether you are the principal actor or a party in the sort of purest sense of that word, well, you don't get an acquittal on that basis. Because even if you're a principal, you're still a party, according to section 21 sub 1 sub A. So it's a way of streamlining the argumentation of the case, we might say. We can also see this idea at work in a case called Thatcher. Now, there, the Crown had suggested that one of two things had happened. Either the defendant had killed his wife himself, or he'd hired someone else to do it for him. And what happens if the jury, as it were, splits on which theory of the case it accepts? Does that mean that we have to acquit Mr. Thatcher? Absolutely not. Court in Thatcher's quite clear that in either case, Thatcher is just as guilty of the offense, whether it's as the principal actor, i.e. he killed his wife himself, or as a party to the offense by aiding and abetting someone else to do it for him. So even if the jury disagrees amongst themselves about why it is that he's guilty, it makes no difference. Again, Canadian law treats the party and the principal to the offense as morally equivalent, equally blameworthy. Now, the criminal code sets out a number of different ways in which one can be a party to an offense. To get us started, let's focus on section 21 sub 1 subs B and C. So here we are back at section 21 sub 1, and now we're going to move to subsections B and C, and you'll note that everyone is a party to an offense who does or omits to do anything for the purpose of aiding any person to commit that offense, or C, abets any person in committing it. So we have sub B setting out aiding and sub C abetting. So let's talk first about the Actus reus for aiding or abetting. Well, the first point to make here is that on the sort of language on the face of section 21 sub 1, particularly 21 sub 1 sub B, the ways in which one can aid in the commission of offense is left completely wide open. Essentially, you can anything that you do that aids another person to commit an offense can in principle satisfy the actus reus requirement for 21 sub 1 sub b. Furthermore, the language of section 21 sub 1 sub b is also clear that one can aid through omission. So if you have a legal duty to intervene and stop this offense from being carried out, whatever offense it is, and you don't, if you fail to discharge your legal duty, well, that can also make you a party under 21 sub 1 sub b. So we can easily think of a couple of examples of individuals who fail to intervene, and on that basis alone may be regarded as having aided the commission of the offense. So if we think about, say, a police officer who fails to intervene to stop one of the prisoners under his care being beaten. The police officer who fails to intervene in a situation like that plainly has a legal duty to intervene, a legal duty to look after the prisoner in his care, and so by failing to discharge that legal duty, according to the terms of section 21 sub 1 sub b, that officer may be regarded as having aided the commission of the offense, aided the assault perpetrated by the others. Likewise, if we imagine a case in which one parent is abusing a child, and the other parent does nothing to intervene, again, that other parent has a legal duty under section 215 sub 1 sub a of the code to provide the necessaries of life to the child, and to the extent that she does not discharge that duty, she again may be regarded as having aided the commission of the offense. Now, as this discussion suggests, in determining whether or not one has aided the commission of an offense by omission, of course, our starting point is the same starting point that we had when we were looking at omissions more generally. We have to ask, okay, was there a legal duty to act on the part of this defendant? If there wasn't, then there can't be a criminal omission, right? One can only aid the commission of an offense by, as it were, doing nothing, if one had a legal duty to do something. So that's the first just observation here, that we're not in any sort of different terrain, legally speaking, than we were in when we were talking about criminal omissions more generally. It's very much in this spirit that the Supreme Court in Dunlop and Sylvester makes much of the idea that, look, you cannot be regarded as a party to the offense merely because you happen to be present at the scene of a crime as it was happening and did nothing to stop it. That by itself, that mere presence, doesn't get you to party liability. So there's the ambiguity, as it were, or the paradox of Dunlop and Sylvester, that by apparently doing nothing, you may be, in a sense, regarded as doing something, i.e. offering positive encouragement of the criminal act. And we can see this sort of reasoning going on in a number of cases, particularly sort of gang cases, in which it's sometimes suggested that by adding your presence to a group as it is engaging in various criminal acts, you are implicitly emboldening that group. After all, you've added yourself to their numbers. And even if you don't yourself actively engage in a criminal act, you are, as it were, emboldening the others. And in a sense, you may even be regarded as having provided facilitation, because, of course, by making the group bigger, you may be discouraging others from intervening. So again, there's a fuzzy line here between, as it were, mere presence, which cannot give rise to section 21 sub 1 sub B or C liability, and adding your presence and thereby encouraging the criminal act, or indeed facilitating that act. Now, does this mean that everyone who is present at the scene of a crime is at least at risk of being regarded as a party? Well, no. Keep in mind that there's an additional element here, the fault requirement. Here we are back at section 21 sub 1, and you'll notice this language of for the purpose of. So it's not enough that you've done or omitted to do something you had a legal duty to do and thereby facilitated the commission of an offense or encouraged the commission of an offense. You must have done or omitted to do that thing for the purpose of facilitating the commission of the offense. And here, keep in mind everything that we learned about subjective fault. So that language of for the purpose of, we're looking for intention, an intention to aid another person to commit the offense. And what do we know about intention? Well, we know that it is not synonymous with desire. You know, remember Hibbert, which concerned this very section. And there, recall that the Supreme Court was clear that even if you don't want to necessarily see this offense carried out, you may nonetheless intend the offense to be carried out, or at least intend to facilitate the commission of that offense. Now, the flip side is that, of course, in order to be said to have the intention of aiding a person to commit an offense, you must have some awareness that the principal actor intends to commit the offense. So there's a buried knowledge requirement here. And now, establishing knowledge is not enough to be regarded as a party under 21 sub 1 sub B. There must again be that intention. You must be engaging in this conduct or omitting to fulfill your legal duty in order to facilitate the offense. Alternatively, there may be oblique intent. So if you have knowledge to a certainty that your conduct or your omission will facilitate the offense, that will also satisfy the fault requirement under 21 sub 1. But section 21 sub 1 is only one provision in the code dealing with party liability. We can look to other provisions as well. So here is section 21 sub 2 of the criminal code, which sets out what we might call common intention party liability. And rather than read this provision, which is very complicated and convoluted, I'll just set out the three elements that must be established in order to count as a party under this provision. So the first is that there must be an intention in common among two or more actors to carry out an unlawful purpose of some sort. The second factor, one party with the intention of assisting the others in carrying out that unlawful purpose must commit another offense. And what this provision says is that to the extent that the others know or ought to have known that carrying out the unlawful purpose would entail that further offense, everyone is liable for the commission of that offense, even though, strictly speaking, they'd only formed an intention in common with respect to the, as it were, larger unlawful purpose. Now, I'm just going to draw your attention to some of that language in section 21 sub 2, specifically each of them who knew or ought to have known that the commission of the offense would be a probable consequence of carrying out the common purpose. Now, some interesting constitutional problems arise out of that language. Suppose that someone, one of the members of this group, in furtherance of the common unlawful purpose, carries out an assault. That person may be convicted only if the Crown establishes an intention to apply force. Remember the elements of assault. But according to section 21 sub 2, all of the other individuals who formed that unlawful purpose may be convicted of assault as parties to the assault, so long as they ought to have known that force would be applied in the course of carrying out the unlawful purpose. So in a sense, what this provision does is creates a kind of constructive fault. Now, this raises potentially serious constitutional problems if the offense in question is one of the few offenses that actually require, as a constitutional matter, subjective fault. And in particular, offenses like murder or attempted murder. Now, in a decision called Logan, the Supreme Court resolved this problem in a superficially attractive way by holding that if the offense requires constitutionally subjective fault, then the Crown simply won't be able to rely on that language of or ought to have known. And I'll just highlight that there. In establishing party liability for that offense under section 21 sub 2. So the upshot is that where that further offense constitutionally requires proof of subjective fault, one cannot be convicted as a party to that further offense merely on the basis that one ought to have known that the further offense would be committed. There must be knowledge that the further offense would be committed. Now, what if the further offense is one of subjective fault, but there's no constitutional requirement that it be an offense of subjective fault? So it's constitutionally permissible for Parliament to rewrite that offense and make it an offense of objective fault. Now, that doesn't change the fact that the principal actor who engages in that offense, that further offense, there must be proof of subjective fault, but everyone else can be convicted on the basis of objective fault, on the basis of what they ought to have known. So there's still some wonkiness here, arguably at the level of principle, but the court in Logan doesn't think this is super problematic. It's defensible because the whole point of section 21 sub 2 is to make people think twice about embarking on criminal enterprises with others, and to the extent that they do, hold them accountable when their efforts at carrying out one unlawful purpose explode into a bunch of other offenses. And in any case, of course, Section 21 sub 2 is just as much part of the code as any other provision setting out criminal offenses. Now, the very nature of Section 21 sub 2 is such that it creates what we might describe as abandonment issues. Suppose that I embark on a course of action with others intent on a common intention to carry out an unlawful purpose, and then having formed this common intention, well, now I want to back out. Perhaps taking seriously some of the sentiments expressed in Logan, to the effect that, well, we don't want you guys engaging in common unlawful purposes. Okay, well, now I want to back out. What does it take for me to do that, such that I won't be held responsible for any further offenses carried out by the others in furtherance of that unlawful purpose? Well, in Gauthier, the Supreme Court articulated a three-part test for abandonment. Again, this is a test that applies only for Section 21 sub 2. The court in Gauthier made it clear that there must first be an intention to abandon or withdraw from the unlawful purpose. Second, there must be timely communication of this intention to the others involved in the common unlawful purpose. And finally, the notice must be unequivocal. And why this test? Because this is a burdensome test. Well, it relates to the rationale underlying Section 21 sub 2 liability. By forming a common purpose with others, one sets in motion a series of events in which others are emboldened to engage in criminal acts. In order to successfully abandon, to sever your liability for whatever it is that they wind up doing in furtherance of that unlawful purpose, you need to do what you can to undo your contribution to that chain of events. And so you must, again, communicate in a timely fashion your intention to abandon this unlawful purpose to the others and in an unequivocal way. So what if we're not talking anymore about abandonment under Section 21 sub 2? What if we're talking about abandonment under Section 21 sub 1? Keep in mind that for 21 sub 1 to be in play, for your party liability to be engaged under 21 sub 1, we're talking about conduct that you've engaged in, or an omission that has facilitated criminal conduct. So you've already aided, you've already encouraged this criminal act, whatever it is. So it's no longer that you've just articulated or coordinated an unlawful purpose with others. You've now made your contribution, or you've already made your encouragement. So with that in mind, the court in Gauthier is clear that you need to do much more than just communicate an intention to abandon to the other actor or actors, because they may just shrug their shoulders and say, well, we're sorry that you're sorry, but you've encouraged me to do this, or you've facilitated the criminal act. You've already done your part. We don't need you anymore. And for that reason, just communicating however timely a fashion, however unequivocal a fashion to the others isn't enough. You have to do that. But you have to do more than that. Because what the court in Gauthier suggests is that you must show reasonable steps if you want to argue that you've abandoned the criminal act to neutralize the effects of your participation. And what does that mean? What more do I need to do beyond having my intention to abandon or withdraw from the act to communicate in a timely way my intention to the others, communication that is unequivocal? What more must I do? Well, that might be calling the cops. It might be warning someone. Finally, keep in mind that sections 21 through 23 of the code apply even if we cannot convict the principal actor for the offense in question. Now, why would that be? Well, it might be because we can't identify the principal. We know that an offense was committed. We know that the defendant facilitated the commission of that offense or encouraged the commission of that offense, or was part of a common intention to carry out an unlawful purpose, etc. But what we don't know is who the principal actor actually was. Well, this is not a bar to convicting the defendant as a party to the offense. Moreover, it may be that we can't convict the principal because, quite simply, the principal actor was underage, below the age of criminal responsibility, or perhaps because that actor was acting involuntarily. Again, the mere fact that we cannot convict the principal does not mean that the defendant cannot be liable as a party to the offense. So that's all for today. I just wanted to make a few observations about party liability, and going forward, we're going to be looking next at inchoate liability. See you next time.